My lords, my ladies, permit me to just conclude with giving a bit of a context in the Conchella matter. I'm not going to explaining anything because, my lords and my ladies, the decision speaks for itself. The decision is a decision of 5 judges of the High Court. In particular, my lords and my ladies, paragraph 97 is instructive. 97B in particular, if I may, reads that the exercise of powers under Article 165(4) of the Constitution, though constitutionally underpinned, is administrative in nature. They go on to add that being administrative in nature, the said mandate can be exercised by the Deputy Chief Justice when the Chief Justice is absent, when necessary, or if for good reason the Chief Justice is unable to exercise the mandate. At D, they conclude that in the present circumstances, the rule against bias and the rule that no person shall be adjudged in their own cause dictates that the Chief Justice, being the main respondent in the instance petition, could not assign judges to hear the petition. My lords and my ladies, that is the absurdity that learned senior counsel, Professor Gidu Wigai, was talking about. Take it a step further. Is it therefore their case that if, as contemplated by your Lord, their lordships in that matter, if for one reason or the other, the Honorable Chief Justice is unable to perform the functions of that office, is it therefore their case that no matter that requires constitution of a bench will be heard or determined? That certainly would be an absurdity that the law would not have contemplated. That said, my lords and my lady, one of the things that will play out by close of business these submissions is that our learned friends from the other side have very deliberately taken to concealing what would otherwise be material information before this court. I say that for 2 primary reasons. I want my lords and my lady to make reference to their own application, to the grounds supporting the application. They start, the application is based on the affidavit of Honorable David Muja Matenge and other grounds. The other grounds include A, that on the 18th of October 2024, the petitioners herein filed the instant petition together with an application under certificate of urgency seeking conservatory orders restraining the assumption of office by the second interested party pending the hearing and determination of the application and petition. They go on to say that on the same day, the matter was placed before the Honorable Justice Mongo, who considered the matter, and in light of the urgency of the matter and the weighty constitutional issues raised, the Honorable Judge issued the conservatory orders sought in the first instance and certified the matter as raising weighty constitutional issues and referred the matter to the Honorable Chief Justice to constitute a bench to hear and determine the petition. This is where now the story starts. That on the next day, being Saturday, 19th October 2024, the petitioners were surprised by the turn of events wherein they were served with the order of this Honorable Bench stating that the first and second respondents' applications dated the 18th October 2024, in bracket the applications for were to be had for their inter partes hearing on the 22nd of 2024. Why do I say there is deliberate concealment of material facts? It is because, my lords, looking at the files that were coming up before this court today, that is E565 of 2024 before the court in Nairobi, and E015 of 2024 in Kerongoya. We immediately, upon learning of the orders that had been issued and which have been adverted to here, filed an application. It is on record. That application, my lords and my lady, sought several prayers. One was that we wanted to have that application certified urgent. Like in their case, our application was certified urgent. Again, we asked that the court considers hearing the application outside the normal court hours, including a possibility of being heard on a Saturday. My lords and my ladies, that prayer was not granted. We also, as a third limb of our application, asked that the court considers granting an ex parte order staying the decision of the Honorable Justice Mongo and the Honorable Justice Waita in the Nairobi matter. Again, my lords and my ladies, that prayer was not granted. What followed was then the court, as would be the normal practice of that court, gave directions on how this application was to be dealt with. That is how we ended with the date of 22nd of October 2024. And why this is important, why is it their case that when they file an application and get orders, it is convenient, it is okay, there is justice. When they get another order in Nairobi, it is okay, there is justice. When we get an order merely certifying our matter as being urgent, then there is, all hell breaks loose. And we're saying, if only our colleagues had sought to present this material before this court, we would not be talking about what we're talking about now. It would have been manifestly clear that we were here on account of an application. My lords and my ladies, I've had very strange submissions coming up this afternoon. Submissions including that at the ex parte stage where the court is supposed to be giving directions, the parties expected that the court to have been given notice. Since when, my lords, do the courts in this division, and indeed any other division, attend to matters under certificate, and at the ex parte consideration of those orders, invite parties for hearing of those orders? Why then do we call them ex parte? That submission, my lords and my lady, I repeat, is not for the consumption of this court. That submission can only go to serve an audience that is outside this court, because the people in this court are fully aware of the rules governing the conduct of matters in this court. But also, allow me a few more minutes just to point out a few other areas which then would speak to the reality of why then the omission of this material fact is then now being used to place this insinuation that the court either did something that was untoward, or the Honorable, the Deputy Chief Justice did something that is untoward. My lords and my lady, at paragraph D, the respondents in the application say, subsequent to the reference of the matter to the Chief Justice on the 18th, the petitioners reasonably expected that once the Chief Justice issued directions on the file regarding empanelment, the petitioners would also be invited for mention before the bench for directions as was directed by the Honorable Judge. If they didn't have an application, on what basis, therefore, was an order going to be issued to them? One would have expected that would be something that would come from a party not represented. But a party represented would certainly be talking to an audience other than this audience. At paragraph G, my lords and the lady, they say they now have a direct accusation on her ladyship, the Honorable Deputy Chief Justice, say that the Deputy Chief Justice violated Article 1, 10, 27, and 50 of the Constitution in ordering this bench to hear and determine 3 matters in which conservatory orders had been issued against the government of Kenya and its organs, namely, there is no such order that came from, and a perusal of the file would speak for itself. All that the Honorable, the Deputy Chief Justice did was to constitute the bench. And in anything, this same bench is a bench that has been constituted by the Chief Justice herself. Questions that we ask ourselves: why is it that when we appeared before this very bench last week on Tuesday, on the hearing of their own application, we sat up to midnight? Today, because it is the issue is on the other side, it becomes irregular. That cannot possibly be a parity of arms when you're dealing with a question of justice. Why is it that when they went all over asking for orders, and this speaks to why there are only 2 matters that came before this court, they filed a number of cases. In those other cases, there were no orders. What business did we have filing applications in those matters? We only felt that we were aggrieved with these orders specifically because the effect of those orders were to suspend a provision of the Constitution. And that's why it's important for us that we deal with them. As we seek to deal with them, the only way that the rules of this court establish is that we make an application. And also, my lady, I look at, finally, I think their ground number L, that they also sought to know the circumstances that led the Chief Justice to delegate to the Deputy Chief Justice. That I think has been spoken to. My lords, my ladies, what then comes out is that if our counterparts had been candid with the facts in the file as they speak, we would not be wasting time as we are right now. We would have had an opportunity to speak to the matters on the basis of the accuracy of the files. We would not be casting aspersions on the court as we have seen. We would not be casting aspersions on her leadership, the Deputy Chief Justice, as we have seen. We will not be casting aspersions on the Chief Justice as we have seen. My lords and my lady, I repeat that submission is meant to achieve two reasons, and two reasons only. One, to delay the proceedings that are before you today. We have an application, and at the right time we'll be seeking an existing public card. And number two, to then create this negative impression, which I suppose is meant to be used at a later stage. I rest my case.
Thank you, my lords and